Hello everyone, this is day 40 of Polity Daily Drill. Let's begin. First question. Consider the following statements with respect to the suspension of MPs in India. So last year, as we are all aware, that over 100 MPs were suspended in the country, in the parliament. So this is a question on that very topic. So first one, the Speaker of the Lok Sabha can suspend an MP for disorderly conduct without a vote in the House. Now see, there is one rule 374 under Lok Sabha rules which says that you can suspend an MP, of course, for disorderly conduct, but it requires voting in the House. However, there is one more rule 374 capital A. This says that you can actually suspend an MP, meaning the Speaker can suspend an MP for at least 5 days or the remainder of the session, whichever is less, without any need for voting in the House. So statement 1 is correct. This is nothing but rule 374 capital A. Number 2, a suspended MP, while not eligible for a daily allowance, can still take part in parliamentary committee meetings of which he or she is a member. Now see, when an MP is suspended, of course he or she is not eligible for the daily allowance, plus he or she cannot give any notice, plus he or she cannot take part in any parliamentary committee meeting as well. So 2 is incorrect. Right answer is A. Which of the above statements is or are correct? A. 1 only. Moving on to question number 2. Consider the following statements. While an adjournment motion in the Lok Sabha requires the support of 50 MPs, the adjournment of daily agenda in the Rajya Sabha under Rule 267 can be moved by a single MP. This statement is absolutely correct. Adjournment motions are motions raised only in the Lok Sabha which suspend the agenda of the day. We do have a similar concept in the Rajya Sabha which is under Rule 267. Now for adjournment motion to be accepted, it must be supported by at least 50 MPs, whereas any MP can move a motion under Rule 267. Number 2, an adjournment motion can be moved only with the prior permission of the Speaker, whereas a motion under Rule 267 does not require the prior permission of the chairperson. This is wrong. When you move a motion under Rule 267, you need the prior permission of the chairperson. Without the permission of the presiding officer, how can you move a motion to suspend the daily agenda of the House? So 2 is wrong. Number 3, in the 17th Lok Sabha, no adjournment motion was discussed. Absolutely correct. Neither the 16th nor the 17th. In both these Lok Sabhas, not a single adjournment motion was discussed. The 17th Lok Sabha refers to the time frame 2019 to 2024. The 16th Lok Sabha refers to the time frame 2014 to, of course, 2019. So 3 is correct. 1 and 3 are right. How many of the above statements are correct? B. Only 2 are correct. Moving on to question number 3. Which of the following statements about governors of the states in India is correct? As per the constitution, they act as chancellors of all the universities in the state. Now this is of course incorrect. Why? Because it is not as per the constitution but as per various state laws. B. A bill passed by the state legislature on a subject in the concurrent list that violates a central law on the same subject can be declared valid with their assent, meaning with the assent of the governor. Now not with the assent of the governor but with the assent of the president. We know this very well. This is a provision under which article? 254, extremely important, and the example is the very famous anti-NEET bill which was passed in the Tamil Nadu Assembly. So B is also wrong. C. They can use their clemency powers against sentence by court martials only with the prior permission of the president. Utter nonsense. Governors under Article 161 do have clemency powers, but they have no such clemency over court martials, meaning military court punishments. So C is also wrong. This means D, none of the above is correct. Moving on to question number 4. Consider the following statements about Nari Adalats in India. They are women-only courts that address individual cases and raise awareness about social schemes. Absolutely correct. They do not hold any legal status. Absolutely correct. No legal status as of now, and are primarily focused on reconciliation, grievance redressal, and creating awareness of rights and entitlements. True. And it is an initiative of the Ministry of Women and Child Development under the Sambal scheme or sub-scheme of the Mission Shakti. This is also true. All three are correct. How many of the above statements are incorrect? D. None of the statements are incorrect. And the last question for today, consider the following constitutional dignitaries: Chairman of UPSC, CAG, CEC, SEC. How many of the above can be removed in the same manner as a Supreme Court judge? State Election Commissioner, Article 243, capital K, he or she is removed in the same manner as a High Court judge, and we know very well the mode of removal of High Court judges and the Supreme Court judges is the same. So yes, CEC, of course, a constitutional body, the removal procedure mentioned under Article 324 clause 5 is correct. CAG, again a constitutional body, Article 148 chapter 5 part 5 of the Indian Constitution deals with CAG, and yes, they are also removed in the same manner as Supreme Court judge and the chairman of UPSC. So in this case, sadly, the chairperson of UPSC is not removed in the same manner as Supreme Court judge, meaning there is no voting in the parliament. The Supreme Court will conduct an inquiry and give its report to the President of India, inquiry by Supreme Court. And based on that report, the member of the UPSC, including chairman, can be removed. So 2, 3 and 4. How many of the above can be removed? So C, only 3. That's the answer. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that's all for me. Jai Hind.